My name is Nancy Case, and I'm a senior associate at Matthiesen, Wickert, and Lehrer, and my specialty, if you will, is obtaining reimbursement for self-funded ERISA plans. Through the years, I've encountered many obstacles to reimbursement for my clients, and through the years, the U.S. Supreme Court has mapped out the path to reimbursement from legal to equitable relief. Along the way, plans have changed the terms of their plans in an attempt to thwart the never-ending arguments that seem to arise when it's time to settle a participant's underlying case. So today, let's start with the beginning and move quickly to what you need to know if you're considering drafting changes to your plan. Starting with the statute. The civil enforcement section of ERISA clearly states that a plan fiduciary is only allowed to obtain equitable relief. Therefore, it's very important whether the court perceives subrogation as an equitable remedy or a remedy at law. In looking at the type of claim, courts look to the substance of the remedy sought and not to the title of the remedy. Money damages, of course, are the classic form of legal relief. So does ERISA dictate the provisions of my plan's subrogations and reimbursement language? No. A plan's right to recovery under ERISA is limited to enforcing the terms of the plan or of ERISA under ERISA 50283. So ERISA has no general right of subrogation or reimbursement. The right to recover must be in the plan language. So getting back to the Supreme Court map, let's briefly review the key cases and their impact on plan language. So back in 2002 in Great West Life versus Knudsen, the relevant ERISA plan contained a reimbursement provision which stated that the plan administrator had a first lien upon any recovery, whether by settlement, judgment, or otherwise, that the beneficiary received from a third party not to exceed the amount of benefits paid by the plan. The Supreme Court held that seeking to impose a constructive trust or equitable lien on particular funds or property in the defendant's possession would constitute equitable relief. However, the Supreme Court found that such relief was not demanded in this case because the funds to which the petitioners claimed an entitlement were not in Knudsen's possession, but rather in a restricted trust. So the Supreme Court held that the relief sought was not equitable, but legal, because it was the imposition of personal liability for the benefits that were conferred upon Knudsen. Moving on to Sereboff versus Mid-Atlantic, the Supreme Court was faced with the same question as Knudsen, but with a fact pattern in which the beneficiaries retained the monies at issue in a specific fund. So the Supreme Court held that the basis of the claim was equitable because a contract to convey a specific object, even before it is acquired, will make the contractor a trustee as soon as he gets title to the thing, quoting a 1914 case, Barnes versus Alexander. Mid-Atlantic was seeking relief available at the time of the divided bench, namely the enforcement of an equitable lien established by an agreement. Thus, Knudsen was confirmed, but things still got more interesting. In the McCutcheon case, the complicating factors of equitable defenses were added to the mix. In McCutcheon, the relevant ERISA plan required that U.S. Airways pay McCutcheon any medical expenses, but the plan contained no explicit reference to attorney's fees. So pursuant to the principles of contract law, the Supreme Court held that, in fact, an unambiguous plan overrides any unjust enrichment doctrine. But if the agreement governs, the agreement governs. The reasons for looking to a contract's terms do not permit an attorney's fees exception. We have no doubt that the common fund doctrine has deep roots in equity. Those roots, however, are set in the soil of unjust enrichment. And as we have just explained, principles of unjust enrichment give way when a court enforces an equitable lien by agreement. So the agreement, i.e. plan language itself, becomes the measure of the party's equity. So if a contract abrogates the common fund doctrine, the insurer is not unjustly enriched by claiming the benefit of its bargain. Even in equity, when a party sought to enforce a lien by agreement, all provisions of that agreement control. So in the specific factual context of McCutcheon, the Supreme Court held that the plan was silent on the allocation of attorney's fees. So the court concluded that where a plan is ambiguous on the payment of attorney's fees in the context of a reimbursement provision, the common fund doctrine provides the appropriate default. Thus, where an agreement is explicit about attorney's fees, then the agreement controls over any equitable doctrines, including the common fund doctrine. So fast forward to Montanile. Montanile was severely injured by a drunk driver, and the relevant facts played out in three ways. First, Montanile received monies from his ERISA plan to cover his medical expenses. Then, Montanile recovered from a suit against the drunk driver and his insurer. and then Montanile spent the whole recovery on non-traceable items. The Supreme Court held that the plan was seeking a legal, not equitable remedy. Why? The plaintiff could not attach a defendant's general assets instead because those assets were not part of the specific thing to which the lien attached. So the Montanile decision will likely lead to a near series of litigation determinations of when settlement or other third-party proceeds are properly commingled with other assets. So the plan fiduciary may enforce the lien against other assets or what will be considered traceable versus non-traceable assets. We're already seeing some of this. Maybe this is an obvious question, but does my plan have to advance benefits for claims that are someone else's fault? No, but if your plan language is good, you exclude such payments already. And your coordination of benefits is clear that MedPay and PIP pay first. And your plan clearly explains a procedure for such payments, i.e. exhaustion of benefits and payment ledgers are required, and addresses other policies. There's school insurance policy, workers' comp benefits that need to kick in first, and your sub or reimbursement provision refers to the exclusions and coordinations of benefits sections in your plan. They refer to one another. It's one thing to improve subrogation and reimbursement language, but it's critical that the entire plan get reviewed for consistency and reference among important sections. So maybe this is another obvious question, but what are the plan's goals with subrogation and reimbursement? Maybe another way of putting it is, are there any sensitivities around your plan language? Are you looking for 100% reimbursement every time, in every situation? Is there no reduction for attorney's fees? Do you care if plan participants get good representation? Is that a sensitivity for you? Would a reduction in my plan help get more in reimbursement? You know, maybe there's a plan, the plan provides that the plan's right to reimbursement or subrogation are net of reasonable costs and attorney's fees, but that such costs and fees are not to exceed X% of the gross amount sought by the plan. No reduction for made whole or common fund doctrines? If so, stated carefully. Not only do you want to disclaim the made whole and common fund doctrine, but you also want to state and any other common law doctrine or state statute that purports to restrict the plan's right to full reimbursement. Think about wrongful death and minor estates action. Conclusion of claim. No more incident payments after the settlement. Discretion to decide. Offset and how. Are offsets from incoming claims for benefits or directly from providers by way of a refund? Does the plan want to retain the right to decide how to treat individual situations? Recall, there's a duty to all plan participants to protect the assets of the plan for claims payment. Discretionary authority. It allows the plan the discretion to treat situations differently, but is there a definition of discretionary authority that conflicts somewhere else in the plan? Here's an example. Another section of the plan confers discretionary authority, but then goes on to suggest that any use of discretionary authority will accrue to the benefit of all plan participants. So now you have a conflict. Say you have a 40% reduction in one case for reimbursement because it makes sense under the circumstances, the facts and circumstances of that particular situation. But now that translates to a 40% reduction for all plan participants. You know, real-world example. There have been discovery requests that ask for all reductions on reimbursements for the past X number of years. So you want to be careful about that. Does the plan want the right to request refunds for non-compliance or refusal to reimburse? And how would you go about doing that? Do you want an offset from incoming claims for benefits? Do you want an offset that allows the plan to withdraw benefits directly from providers the plan is paid? What about suspension of benefits for non-compliance? Say the lien amount is growing and growing, and the participant's attorney calls and says, well, we're not going to be able to, liability is a problem. There's some kind of a situation. Do you want to be able to say, okay, well, if you're not intending to reimburse the plan, we will suspend benefits until you acknowledge that the terms of the plan control and that we are entitled to reimbursement, or offset via incoming claims for benefits against all covered members for non-compliance. Again, something that you can restate, put back into place after the reimbursement is understood. So these kinds of provisions can be used along the way to strengthen a plan's position with a reluctant claimant or attorney. Does my plan distinguish between subrogation and reimbursement, and what's the difference? Well, subrogation is the right of the plan to pursue a suit or claim against the responsible third party. But reimbursement is the plan's right to be reimbursed for benefits paid on behalf of the participant from any third-party recovery. Why does it matter? If you want the ability to pursue a third party when a participant doesn't or won't, you'll need to state that clearly in the subrogation section with details about how that works. Otherwise, you're leaving money on the table. A real-world example, I worked for a plan that had a designated low-dollar recovery program. So for any lien amounts or lien claims that were $3,000 and under, we pursued those and using subrogation and annually exceeded recovery goals. Sometimes these are the easiest sources of 100% recoveries, especially if they're numerous. Why do subrogation and reimbursement provisions in my plan document and SPD matter? Well, for a long time, it was assumed that subro reimbursement rights could be found in either the formal plan document or the summary plan description, or SPD. However, the Supreme Court in Cigna v. Amara in 2011 explained that the summary documents, important as they are, provide communication with beneficiaries about the plan, but their statements do not themselves constitute the terms of the plan. So you need a definition like this, defining the term plan. You want to say the name of the plan and summary plan description together and make sure that the subro terms are the same, or this book serves as a summary plan description and also serves as a legal plan document. The SPD cannot alter the plan provision. If the language in the SPD is different than the plan document still controls. Okay, now it's trivia time. Type your answer into the question pane and hit send. So is everybody ready? The trivia question is, what is the first CD burned or printed in America? Okay, your plan language. Is it saying too much or not enough? For instance, the term participant is defined in 29 U.S.C. 1002-7 and generally encompasses employees and former employees. To the extent possible, use the term participant everywhere in your plan document. The term beneficiary is defined in 29 U.S.C. 1002-8 as a person designated by a participant or by the terms of an employee benefit plan who is or may become entitled to benefits thereunder. Use the term beneficiary everywhere when possible. Sometimes this isn't a reality, but if you can use it, use it. Your plan's definitions and what should be defined. These are definite in your subrogation section, and obviously, as we've been saying, all throughout the plan document. You want to define clearly participant, an employee or former employee or beneficiary covered under the plan. You want to define benefits. You want to say all payments related to an injury or illness, including but not limited to medical expenses and other compensation under the plan. So this can also include some processing fees, lost wage payments, etc. You want to define third party very clearly. You want to say that the term third party includes any of the following entities: person, including a negligent participant; corporation, association, government, insurance coverage, including underinsured, uninsured, and med-pay provisions of an insurance policy; and workers' compensation coverage. You want to make sure that you're covered when the plan participant causes the accident that injures all of the other family members who receive benefits from the plan. You want to define responsible third party. You want to say that a third party that is or may be legally responsible for reimbursing the participant for an illness or injury. You don't want to be subject to the proof of legal responsibility. You want to define reimbursement amount. You want to say that the amount of benefits paid by the plan to the participant or on the participant's behalf for the injury or illness for which a third party is or may be responsible, and that the participant is obligated to pay back to the plan out of any recovery. So then you want to define recovery. You want to say that recovery is any and all payments from another source to which the participant is entitled, including but not limited to any amounts allocated to a trust set up by the participant or on the participant's behalf as a result of the participant's injury or illness, including any judgment, award, or settlement, regardless of how the recovery is termed, allocated, or apportioned, and regardless of whether any amount is specifically included or excluded as medical expenses. Are your plan terms clear and unambiguous? Is it clear that the plan is conditionally advancing benefits provided that subro and reimbursement provisions are satisfied? Is it clear that by accepting benefits, the participant agrees to be subject to the terms and conditions of the plan? Is it clear that the purpose of the plan, that its main purpose is to pay covered expenses if they are not payable by anyone else, is clear? Is it clear that the terms are defined consistently throughout the plan? Is it clear that the plan has discretionary authority to advance payments conditionally, determine eligibility, and construe the terms of the plan? Is it clear that the plan is entitled to reimbursement in full for benefits paid to the participant for which another party is responsible? Is it clear that the plan is subrogated to all of the participants' rights of recovery against the responsible third party, which you've defined? Is it clear that the plan is entitled to first priority 100% reimbursement for benefits and expenses paid without regard to the common fund doctrine, made whole doctrine, any other common law doctrine or state statute that purports to restrict the plan's right to reimbursement in full, attorney's fees, costs, future medical expenses, and regardless of paid without regard to whether recovery, as you've defined, is sufficient to fully compensate the participant? Is it clear that the plan may exercise its right of subrogation and pursue a suit or claim if the participant doesn't do so within X period of time? Is it clear that the plan may join or intervene in a suit brought by the participant or on the participant's behalf? Is it clear that the plan has the right to information about any suit or claim brought by the participant or on the participant's behalf? And is there a consequence? Is there a suspension if this information is not provided? Do terms matter if they are only in the subrogation and reimbursement section? Yes, all definitions should be in the same throughout the plan document. Example, you want the definition of incident, illness, injury, member, participant, beneficiary, dependent. All discretionary authority provisions throughout the plan should be the same. As we discussed, when they don't have discretionary authority in one section, state that all plan participants will be treated the same, and any decision, amendment, modification by the trustees, board, plan administrator will benefit all participants. If you have a subrogation and reimbursement provision that grants discretionary authority to accept less than 100% reimbursement, you want to make sure that all of your sections coordinate. You want your exclusion section, coordination of benefits section, and overpayment sections to refer to one another. Okay, discretionary authority and fiduciary duty, and why does it matter? In 1989, the U.S. Supreme Court decided Firestone Tire and Rubber Company versus Brutch, a case in which the court concluded that an ERISA plan administrator's decisions will be reviewed under a de novo standard, which allows the court to take a fresh look at the decision without deference, unless the ERISA plan document confers discretion on that administrator to determine eligibility for benefits and construe the terms of the plan. The plan document grants the administrator such authority. A much less exacting, arbitrary, and capricious standard of review generally will apply. And since Firestone, other Supreme Court decisions have addressed issues related to the proper deference to be afforded to a plan administrator under ERISA, including a case where a plan document, or the court reiterated that when a plan document gives plan administrator discretion to interpret its terms, the administrator's interpretation should be given deference by the court. So as a result of these cases, most employers and insurance companies began to include discretionary language in their plan documents. Courts have held that where the ERISA plan gives the administrator discretion to interpret the terms of the benefit plan, the court must give deference to the administrator's decision and apply the abuse of discretion standard. Recently, however, legislatures and regulatory agencies in more than 22 states have taken steps to ban or restrict discretionary authority in ERISA plans. Each plan has certain key elements, and they include a written plan that describes benefit structure and guides day-to-day operations of the plan, a trust to hold the plan's assets, a record-keeping system to track contribution and benefits payments, and documents to provide plan information to employees and participating in the plan, participating in the plan and to the government. So fiduciaries have important responsibilities and are subject to the standards of conduct because they act on behalf of all plan participants and their beneficiaries. And their responsibilities include acting solely in the interest of plan participants and their beneficiaries and with the exclusive purpose of providing benefits to them, carrying out those duties prudently, following the plan documents unless they're inconsistent with ERISA, holding plan assets, if the plan has any, in trust, and paying only reasonable plan expenses. So the duty to act prudently is one of fiduciary's central responsibilities under ERISA. It requires expertise in a variety of areas. So it's wise to document decisions and the bases for those decisions, meaning if you're accepting 100% or less than 100% rejection on a matter, you want to make sure that that's documented. Does your plan have a clear claim review process and procedure? Following the terms of a plan document is also an important responsibility. The plan document serves as the foundation for the plan operation. So employers will want to be familiar with their plan document, especially when it is drawn up by a third-party service provider. And they want to periodically review the document to make sure that it remains current. For example, if the plan official named in the document changes, the plan document must be updated to reflect that change. These are compliance issues, but in the day of age of the computer and websites for plans, modifications to plans and SPDs are easier and much less expensive to implement. Finally, plan structure. Is my plan clearly structured to meet subrogation and reimbursement goals? I found through years of reviewing plans and trying to draft them and design them for different clients that generally it makes sense to coordinate them in the following way. You'll want a general discussion, especially in an SPD, so that it's very clear to a plan beneficiary exactly what subrogation and reimbursement means. You'll want a definition section that we've been talking about. You'll want to make sure that you have subrogation and reimbursement rights clearly defined. And you will want a participant subrogation and reimbursement responsibility section. You'll want a section that deals with subrogation and reimbursement procedures. You'll want a section that deals with noncompliance. You'll want a venue section, and you will want to be in your nearest U.S. District Court. Check your entire plan for venue provisions, or someone might hold you to your circuit court venue provision in a completely separate section of your plan document. And then you'll want to talk about conclusion of claim. And now I am told that the winner of our trivia question is Teresa DiPaolo from the Hartford, and she got the answer correctly, which is the first CD that was printed and burned in the United States was Bruce Springsteen's Born in the USA. Congratulations, Teresa. You can get with Jamie Breen and decide with her what MWL book you would like to receive. With that, I conclude my presentation today. We'll move on to some questions and answers. Please feel free to contact me if you're considering a plan language review, an update, or revisions to your current plan document or SPD. But before we get to the questions, I want to quickly make you aware of some of the resource tools that we have on our website. If you've never visited our website, I highly recommend it. Our website address is noted on the last slide you're looking at right now with my contact information. It's packed with numerous resource tools that you can utilize at no cost. To name a few, we have 32 subrogation charts that cover a variety of topics, including the made-whole doctrine, health and disability insurance subrogation, statute of limitations, and each of these charts cover all 50 states. We have a subrogation laws by state map where you can click on any state in the map and get laws related to insurance for that state all on one page. You can also refer to a file to us through our Refer a File feature, where you can refer a file to us in 2 easy steps, including attaching the file no matter what its size is. We also have a Ask a Question feature and a great blog. Feel free to like us on Facebook and follow us on LinkedIn because you'll be notified when we post anything new on our blog. It's a great way to keep up with any changes in the law affecting or impacting subrogation recovery. If, after the webinar, you should have any questions, feel free to email me and I'll be happy to answer them. Okay, First question. Given the ruling in Montanile, is there anything I can put in the plan to stop a participant from spending recovery funds on non-traceable items? Yes, you can certainly try. You can include a provision that states the plan's recovery and reimbursement amount, both of which are terms that you will have defined, are recoverable even if the participant's recovery funds have been commingled with other assets, and the plan may recover from any available funds without the need to trace the source of those funds. So that's one way that you can get around that. The next question, is there any way to prevent a participant's attorney from distributing recovery funds? That's a great question, and with the correct plan language, you can certainly try. You will want your plan to state that any party who distributes participants' recovery funds without regard to the plan's right of subrogation or reimbursement will be personally liable to the plan for the amount so distributed, including participant's spouse, dependents, beneficiary, estate, including participant's attorney. So checking on the time, it looks like we can take a few more questions. Okay, question, what is the worst subrogation reimbursement language that you have seen? That's kind of a tricky question because I certainly don't want to call out any clients or anyone in particular, but I am, look for it right now, comes to mind a subrogation provision that was recently presented to me, and it stated something along the lines of this. Now, this is the entire, the self-funded ERISA plan. The entire subrogation section consisted of subrogation. In the event of any payment for services, X shall be subrogated to all rights of recovery against any person or organization except against insurers on policies of insurance issued to and in the X's name, and execute and deliver such documents and papers as may be required, and do whatever else is necessary to secure such rights. And that was it. So basically, there are a lot of problems with that, and very easily there could be no reimbursement rights for that kind of language. So I think that's pretty unusual. It was probably something that's older. That seems to be it for right now. If you have any other questions, please feel free to email me. And have a great day. I hope to hear from you soon. Thank you.